It's good to see you all, at least online. As a matter of technical aspect, please mute yourselves on the screen. You can see on your on the side panel on the screen, you should be able to mute yourself. The reason for that is that we get a lot of feedback from other people's phones, and sometimes if people have a speakerphone, we get a lot of office noise. So it's better to mute yourselves. I can mute everybody, but that means that you can't break in. So, and we would very much appreciate it if you have questions as we go along that you break in, because this is really meant more like a discussion. So feel free to mute yourselves and unmute yourselves as you wish so that we can continue the discussion. So let me just explain what this presentation is, first of all. This is a presentation that is, it's very much shortened from what we give to people who are potential clients. And it's designed around the idea that we want to teach people the kinds of things they should be considering in selecting and working with an estate planning attorney. So it's kind of like consumer information, and actually it is designed around a set of questions which, when people register, we send out a confirmation to them, and along with the confirmation we send a list of 15 questions. And here are the questions. I can send these to you if you want. But bear in mind, these are not the questions that our clients ask us. These are the questions that we think clients would ask us if they knew what we know. And so the presentation is sort of outlined or centered around answering these questions, or at least presenting them so the clients know to ask them. And of course, since we're asking the questions, we have our own answers. And the whole idea is that they can find out how we operate and what our practice is like, and they can make a decision whether they want to work with us. But again, I think I've told some of you that this is really a class that's designed to actually filter people out. So if someone comes, here's what our story is, and here's what our questions are. And once they ask those questions but doesn't like our answers, we're perfectly happy to have them go somewhere else. So if you send someone to this workshop, it's perfectly okay with us that you know, they ultimately decide not to work with us, because it's always best to work with somebody that really fits your needs. Also, when people come to this, we give them a fairly thick notebook with a bunch of tabs in it. The first few tabs are filled up, and they have our bios and the questions, etc. And also the PowerPoint for this presentation, as well as some information about estate settlement, all of which they get and they get to keep. And the purpose of the notebook is so that they can use it as an organizer as they go along in the process. If they decide not to go along with the process, then they can certainly throw the notebook out or keep the information, but that's up to them. But one of the reasons we like people to register is so that we do have a notebook with all the contents ready for everybody when they come. So, if I may, I would like to ask your permission to be blunt. And actually, we start off the presentation after some introductory statements with that. May I have your permission to be blunt? And the reason I'm being blunt is that we make this statement that, in fact, most estate plans don't work. So what do we mean by that? Well, you know, if you have a car and it gets you to your destination, then you're very happy the car worked. And so what we mean is that if your estate plan works, it really meets your expectations. The real problem with the issue of estate plans is that, you know, when do you know whether your estate plan actually worked? And usually when I'm making this presentation, I just stop until somebody answers the question, which of course is after I die. So, and the better question is, when do you know? And that's after you die. So, pardon me, I had to kind of clear my throat. So, Well, that's kind of interesting. And the reason that's important is that what we have is this called the snapshot test. And the snapshot test really is kind of a story where you're saying, well, all right, let's say that you died and you're up in the clouds and you're looking down. Of course, that's the better option to the other, looking up from the other direction. And you're looking down, and if people are doing everything that you kind of expected them to do, running around doing the kinds of things that you wanted them to do in terms of your plan, then your plan is working. But anything else isn't a plan that works. It's not acceptable. So we use this snapshot test to kind of get people to understand that what we're really talking about is trying to get the actual results that they want. And a lot of times the biggest problem is that people really don't know what their snapshot is supposed to look like. They might have a vague kind of an idea. And if you're playing archery, you've got an arrow and you've got a target, and you're going to shoot the arrow and you met your target. In the estate planning world, not only do you not know whether you've hit your target, sometimes it's very difficult to know what the target is. So in order to help clients with that, we have something called the definition of estate planning. That's really what our target is. And this was developed by the people who founded the National Network. And although it has been modified over the years, and they're still using it, although they're actually not members of the network anymore, and they're not actually practicing law, they actually went into the financial world themselves, and they do estate plans for people with $50 million of net worth and above. But they still use the same definition of estate planning. So here it is. It's I want to control my property while I'm alive and well. And of course, everybody knows the first and most important goal most people have is that they want to keep control. And second, I want to plan for me and my loved ones if I become disabled. In other words, I'd like things to be done the same way that I would do them if I were able to. And then I want to give what I have to whom I want, when I want, and the way that I want, all while assuring that my wisdom is transferred along with the rest of my wealth. So, that's essentially what the target is. And when we're talking about transferring wisdom along with the rest of the wealth, what we're really saying is it's not all about money. Giving things the way you want them and transferring your wisdom along with the rest of your wealth means that there's things other than money and taxes that are often very important to people. So, if you're trying to figure out, well, if that's the target, how am I supposed to prioritize what it is that I kind of want to do? So what we'd like to do is use something called the estate planning pyramid. Now, I'm sure you've seen the pyramid used in many other applications, but this is ours. And you can see that at the bottom of the pyramid is me, meaning the client. And we start there because, if you're in an airplane and the oxygen masks come down, they always tell you, please put your mask on first before you help anybody else. And in order to really understand what people want to do, we have to start with them, who they are, what their values are, what their story is, what's their background, where are they coming from. And, if you go to someone and say, what are your objectives, oftentimes you get a kind of a blank stare. Whereas if you start asking them who they are and where they came from and, what they think about various different issues of life, it gives you a much better understanding of the kind of thing that they might like to do. But of course, people don't do planning unless they care about somebody. So the next level is we need to know about the family, or you could substitute the word loved ones if they don't have a family. And of course, people really don't do much planning, excuse me, unless they have people that they care about. Now, the third most important thing is preserving wealth. And this is really the area that we do most of our work in as estate planning attorneys. We help people preserve their wealth. And we find that, people will spend a lot more time and a lot more effort often preserving what they have as opposed to trying to get more. Nobody wants to lose what they have. So that's the area that we primarily work with. But of course, there's also expanding wealth. And here's where we actually talk about collaboration, because we don't work in the expanding wealth area. We don't actually do estate, investment, management, et cetera. and insurance and all the other things. So what we do when people need help there is that we collaborate with financial advisors. And here's where we actually do talk about the importance of collaboration and the importance of putting together a team of people who has a long duration in order to help you transfer your wisdom along with the rest of your wealth. Now, if I could, I'd like to have people just break in because I want to ask a question here. This is kind of a quiz. If you had a jigsaw puzzle and you were going to try to figure out putting it together, which is the piece that's the easiest piece in the puzzle? Anybody have any ideas?
The corners.
Corners, that's one answer, that's right. Any other answers? Well, you know, this is a question that is asked. This presentation is actually given a lot to attorneys as part of an education program that the network does, and it's been asked thousands of times over the last 10 years or 10 or 15 years. And what the professionals always seem to say is, you know, colors or corners or edges. And usually that's because we're talking about what our orientation is to solve a problem. That's how we solve the problem, and we look for the colors and the corners, etc. But actually, there's two answers to this that are pretty obvious to most people in the audience, and one of them is, well, that would be the last piece. And the other one is, well, that would be the first piece. So you can see that from the client's point of view, the last piece, which is our favorite answer, is the one that's the easiest to do. And that's the reason for that story is that from our point of view, saving taxes is actually the easiest thing to do. So you know, if you don't know how to save estate taxes, for example, and in some cases income taxes in the area of expanding wealth or preserving wealth, you know, you probably shouldn't be practicing in this area. So that is the last piece that we like to talk to clients about, and often they'll say, well, I trust you. I know you're going to save the taxes as much as you can. I'd rather talk about the other stuff. So why that's important is that the whole idea here is to kind of turn the traditional planning ideas upside down, because, you know, as an estate planning attorney, when I went to law school, the first thing I learned was about the taxes. So the point of this is to try to focus on the client goals and give them solutions that you know, make their planning easier to approach. And it kind of it turns the whole traditional planning approach upside down, because most of us begin from the point of view of, okay, let me see what your finances are, and I can figure out how to save your taxes. And there's a reason for that. The reason is that most of us are trying to figure out what kind of a template we're going to use. And, you know, we typically talk to clients about 3, and this is a longer discussion, but there's the template we use for clients, couples with more than $5 million, a template we use for couples with less than $5 million, and a template we use for single individuals. And of course, the $5 million is the federal exemption amount. So what this does is try to contrast the traditional approach to our approach, which we call the truth approach. And typically and traditionally, the debate about planning has been about, you know, which of the documents. You know, are we going to have a probate plan with a will, or are we going to have a revocable living trust plan? One of the kind of revolutionary ideas that I've sort of come to really believe in is that, you know, if you have a probate plan and you're up in the clouds and you're looking at your snapshot and everything is happening the way you expected it and wanted it to happen, well, that's a plan that works. It doesn't matter whether it was done through a will, and it doesn't matter whether it was done through a trust. Now, I strongly favor revocable living trusts as the basic method of doing estate planning, but from our point of view, really, it's not about the documents. The documents are just a stack of paper. It's about the results. And the way I like to put it to most of our clients is, it's really about what people do. And so we want to get to the results rather than just look at what the documents might be. And that's where we're headed, is to try to do that. So what we realize is that our clients actually face 4 major estate planning challenges. And that's mental disability, asset transfer upon death, taxation, and personal planning goals. And all of those areas are things that we try to address in our counseling with them. As a matter of fact, the Truth About Estate Planning used to be 3 hours long. We divided it in half. It's now about an hour and a half when given to clients. And the other half we have online. We call that Designing a Plan That Works. We're happy to have you go look at that. It's right on our website. And that's the technical aspects of actually addressing all of these issues. So I'm going to pass over that fairly quickly, but it's important that you realize that what we're trying to do is to address a bunch of different planning challenges, and that the clients learn a lot of different things about how we do that. So the key to an effective plan is really several things. First of all, it's personalized counseling. You know, if we don't know what you really want to do, and we don't tell you what you could do or help you understand what you could do before you decide what you should do, then you're not going to be able to do planning the way you really would like to do. You're not going to be able to accomplish all your goals. Sometimes people discover that there's something that they could do that they didn't even know was available, and resolved a question they didn't even know they should be discussing. So, the first and most important thing is to be sure that they get personalized counseling, as opposed to just some document templates and running documents as often as we can. The second, of course, is proper asset ownership. If the assets aren't lined up with what the plan expects, then the plan isn't really going to work. You can get all the counseling that you need in the world, but if you don't actually fund your plan or transfer the assets so that they're lined up the way they're supposed to be, then that's the titling of the documents. That means that your plan's probably not going to work. Just as an aside, there was a case decided in Iowa recently where an advisor had his client go to an attorney. They did a revocable living trust plan, and the advisor helped him fund the trust, did all the funding with him, et cetera. And then a couple of years later, the client wanted to make some changes, so the advisor referred him to another attorney. And the other attorney said, well, okay, we're just doing a will, or thought they were just doing a will, never asked the client about what their assets were, and so did a will for the client. The will said, I want to give $100,000 to a friend, and I want to give a certain amount of money to this charity. And then the client died. But of course, all the assets were in his revocable living trust that had been done 2 years before, and so neither the charity nor the client, or the friend, got their, or was going to get their disposition from the will. And so guess who got sued? Not just the lawyer, but also the financial advisor. And on a summary judgment, the court said, the financial advisor was liable as well, because he should have told the lawyer that there was funding and where the assets were. So proper asset ownership meant, in this case, that they should have been modifying the trust, not providing a will, because the trust had all the assets owned through the trust. So if you have proper asset ownership, then that's going to work. But of course, if we start the funding and then somebody lives for a long time, guess what happens? The assets tend to fall out of the trust, or the beneficiary designations change from the trust or otherwise in insurance or retirement accounts. And so we end up with a trust that's not funded, and that means we end up with a probate, which typically is not what clients wanted to do. So it's important to have what's called a formal review process, and that's what our maintenance program is really about. And what we do is we want to review all the assets every year to make sure that we have the titling up to snuff and everything's lined up with what the plan is supposed to do, how it's supposed to perform. And then, of course, controlling the transfer process itself when somebody dies, or even if they become disabled, that's the important thing. And when we're talking to clients here, it's important for them to understand that in many cases, in most cases, matter of fact, the people that they designate to be the people who are helping them, their powers of attorney, their executors, their successor trustees, are usually individuals that they know. And these are individuals who really they have day jobs. They don't work in this area very much. And so what they need to know is what to do, how to do it, and how to pay for it. So we ask people in the audience at this point, we have this certain question. We say, you know, how many do you think if you died tonight that your family or your loved ones would be prepared? And we ask a show of hands. And usually there's no hands that come up. And of course we ask that because what most people think about prepared is they know what the name of the attorney is and how to get in touch with them. But actually, all right, so they get in touch with the attorney, and then it's the attorney that's telling them, okay, here's what you're going to do, here's how you're going to do it, and here's how you're going to pay for it. But particularly for a surviving spouse who's in the process of mourning at that time, who might not know what's supposed to happen or how they're supposed to pay for it, what kind of leverage do they have in that conversation? They've just hired the most expensive teacher that they can. So one of the more important aspects of this is making sure that people understand exactly what they're supposed to do, how they're supposed to do it, and actually let's disclose what actually the total costs of it are. So in order to actually accomplish these keys, to get these keys done, that's why we recommend to people that they adopt a three-step strategy. And that is to develop your plan with counseling-oriented planning partners. That's step one. Commit yourself and your family to a formal and continuous maintenance and education program. And number three is to secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. Now let me just start from the back end. Securing appropriate assistance doesn't just mean the attorney. What it also means is not just the family, but also the financial advisors who are helping the client during their lifetime and who understand why a lot of the decisions are made. So one of the things that we want to do is we want to make sure that the financial advisor is along for the ride to kind of fill the empty chair, because let's say that the husband has died, and of course in all of our examples the man dies first. But if the husband dies and that's the person that's been handling all the financial affairs with the financial advisor, and the wife, the surviving spouse, doesn't really know much about that, well, the family needs someone to sort of fill that empty chair that the deceased husband left. And that's where financial advisors come in so that people can understand and be involved. And what we're trying to do as part of our maintenance program is to make sure that the relationships between the financial advisors and the helpers, the rest of the family, is strong and secure, because otherwise we end up with not such a stable system or team, and not such a stable set of appropriate people who are for appropriate assistance. So let me talk a little bit about estate planning counseling. One of the things that we do tell clients in this presentation is that what passes for estate planning today, roughly 80% of it, or 85 to 90% of it, is really mere word processing. And by that I mean those three templates that I told you about. Because what happens most of the time is that when people come in to see an attorney, the first thing they ask them is, well, what do you have? And they don't always want to tell them everything, so the attorney will say, well, if you added everything up, how much would that amount to? And the reason for that question is that the attorney is trying to figure out which kind of a plan and what the tax ramifications of the plan are going to look like, so they
Can anyone hear me?
I can hear.
I can hear you.
Okay, so Frank just got dropped off as well as me. I don't know what happened to both of our phones. We'll be right back on.
Okay.
Sorry about that, guys.
Hello, everybody. I don't know what happened. We just all of a sudden got cut off. So I think what I was saying was that what the reason for that question is that we're trying to figure out which of the 3 templates that we're going to use when we prepare the documents. Well, you know, I know that from my personal experience, because before I joined the National Network, that was kind of the way I thought. So what we're really talking about, though, is we want to talk to their clients about their personal planning goals, and, you know, starting with the bottom of that pyramid. What does that snapshot look like? Our job is to try to help them clarify that. And we, at this particular point in the presentation, we are typically talking about some various different stories, starting off with catastrophic illness protection. I'm going to skip those for purposes of time, but I will tell you that the one that most people remember the most is the one about creditor protection. That's called the school bus story. So let me just sort of tell you, and in order to understand the story, you have to understand 2 things. The first is it's hypothetical because I die. And the second thing is that when you if you create a trust and put your property into it, at least in Massachusetts and most other jurisdictions, there are some around here this isn't true, but you can't protect those assets from your creditors by simply putting them into a trust, revocable or irrevocable. So just to bear that in mind. So I die, and at the time of my death, I leave all my property to my lovely wife, Carol. And so, you know, I left it to her. She has it outright. That's the way I wanted things to go. I gave it to her through a will or whatever it might be, so she has it outright. And a few years later, what happens is that she's driving down the street in a rainstorm, and she is distracted by the radio for a second to try to turn it off or turn it down so she can concentrate better. But when she looks up, she discovers that she's right in front of a big yellow school bus, and she slams right into it. And of course, there's 25 kids on it, and Channel 5 is out there checking everything. And so if you were the attorney, who would you rather be hired by? And what then happens to all that property that I gave to Carol? You know, that's going to be subject to claim. So she could lose that to all the school bus plaintiffs. Now, if she were really smart, she might have established a revocable living trust and put all of the assets that I gave her into it. But of course, that doesn't protect her either, because it's a self-settled trust. It's a trust that she created and put the assets in, and under Massachusetts law anyway, she can't keep those assets from her creditors. But suppose when I died, rather than giving the property to her outright, I gave it to her in the form of a trust that's for her lifetime. And so she can be one of the trustees, not necessarily the only trustee, but she can have the right to choose her co-trustee and hire or fire them as long as she has one. So she's pretty much in functional control of that property, and it doesn't belong to her. So when she has that school bus accident, she doesn't lose the money. It's a way of protecting the assets from the vicissitudes of life that she might encounter. So when we ask clients about this, typically we'll ask clients at this particular point, the bottom line is, you know, is there anybody here who wouldn't want to get their property that way? And usually there's very few people who answer that question. Me, I'd rather get it without being protected. And so, you know, if that's true, then what people really are looking at is that they'd like to use long-term trusts and try to protect their assets from the creditors. And that's what counseling is really about. So, of course, we have values promotion. We often talk about things. I have a personal story that I talk about with that. But all of these are different categories of planning goals, or things that have different types of stories that we tell, like the school bus story. So, you know, one of the five different, what we do try to talk to the clients about is the 5 different planning options. You know, there's no documents, there's joint tenancy, there's a simple will with a power of attorney, there's a will with a testamentary trust and a power of attorney, and there's a bare bones living trust, and by that I mean it's one that assets are titled in the trust to avoid probate, but assets go out directly to the beneficiaries, so they actually receive them, personally, and own them individually. And then there's the heritage design planning process. So, a lot of those different, we talk about what those different aspects mean. We talk about how they end up with probate, both living and otherwise, and the various different types of things that we can do with the heritage planning process. So the second step is to commit yourself and your family to a formal and continuous maintenance and education program. And the reason for that is that there are 3 different types of change. We call these the 3 L's, life, law, and learning. So personal financial changes happen over time. The law changes over time. We all know about that. Over the last 10 or 15 years, there's been a lot of changes, particularly in the tax law. We just recently had a case last year that allowed us to do decanting in Massachusetts, which we didn't know if we could do before, trust decanting. And then there's learning. Most people forget that lawyers don't know everything when they graduate from law school, and we continually learn, and as do all of the other professionals, continue to learn throughout our profession, our professional careers. And so, there's a lot of changes that we have. As a matter of fact, in the national network, we meet typically every 6 months at what we call a collegium, and we are able to exchange the experiences and the learning that we've all had. So we come back to our practices with all kinds of new ideas and things that we want to institute. Well, the problem is that let's say that I did a plan, 10 years ago for a client, and I did a very, very good job. I worked very hard. I put in all the bells and whistles. And then I've gone to collegia several times in the interim, and we're 10 years later. The law has changed and that kind of stuff, and I've learned new things that I can do. I've got a new client today, and I'm going to do a plan for them. Which plan would you rather have? Would you like to have the one I did 10 years ago or the one that I did now? And so the problem is that over time, people don't realize it, but their plans get out of date. And the purpose of the maintenance program is to make sure that they stay in date, current with both the law and the changes in their lifetime and in their funding, and also in the kinds of things that we learn and we can do. So, and then the final thing, of course, is securing appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. And what we like to do is explain to clients that there are really 3 factors of overall cost. And the one that most of them concentrate on up front is the cost of the documents. And so that's the kind of thing that people shop around for, and that's fine. But then there are 2 other costs, the cost of updating or failing to update. So what happens when the plan that you have has let's say, a healthcare proxy that has someone that is no longer related to you or involved in your life? Well, what's the cost of having one that's not really up to date with the people you want to help make decisions? So, and then there's the cost after death and the cost of transferring the assets and death tax return preparation. And what we like to do is to try to explain to clients that if they're really going to have good, true peace of mind, they need to cover all of these different costs and understand, actually take a complete look at what all of these costs are. So when we actually meet with them and talk to them about their planning and talk to them about what their planning with us is going to look like, we want to actually go over and disclose all of the costs, not just the upfront cost, but also all the various different costs for maintenance and for estate settlement and the kinds of commitments that we're prepared to make to them for that. And of course, we do go through the actual pricing model, which I'm sure that Christine or I will go through with you at some point. There's no point in discussing it all right now. But it's important to understand that what we're trying to focus on is the overall cost and make sure the clients understand that the way that we can make sure that the overall cost is the least is if we actually pay attention to making sure the plan is up to date, the people are trained, and the people who are the helpers understand how they're supposed to do things and actually how they're supposed to pay for it. And that way that takes a lot of the pressure off of people when they're at their worst point and grieving. So, and that's the rest of the fees. Remember the old thing about Paul Harvey. He said, now's the rest of the story. Well, there's trust settlement administration on disability and death. There's death tax return preparation, and of course there's the probate services if that's there. Now, we try to tell clients that if they're going to be selecting an attorney and they're a revocable living trust attorney, ask them. This is one of the questions. Ask them what's their probate record, and we're very happy to disclose what our record is, which is very low. How successful have they been making sure that nobody actually has a probate with their revocable living trusts? So, traditionally, probate is 2 to 3%, and a standard living trust planning is 1.5 to 2.5%. And with our protocol, using the maintenance program and the three-step strategy, from our point of view, the overall cost should not exceed 1 to 2%. Now, please note that the first two sets of figures are all about the transfer process. All right, so there have been studies. There's AARP's done some studies. There have been some other studies. These are the studies that we put into the materials that we give to clients, but those are estate settlement costs. The third one, the Heritage Design Protocol, and the 1 to 2%, is the overall cost, including both the upfront cost, the maintenance cost, and the estate settlement cost. So that's what we're trying to make sure. The only way that we really can make sure that people have that kind of peace of mind, that they know how things are going to go and that people will actually do what they expect, is if they get trained. And the way for us to minimize the cost of their estate settlement is to have that maintenance program, and that's how we can offer those low percentages. So that's our story, in a summary version of what the three-step strategy is, and that's what we try to explain to clients. And of course, the presentation is quite a bit longer than this, but that's what we're trying to do. So what I'd like to talk to you now about is, the WIFM part of this presentation, what's in it for you, and what it is, what we mean when we're talking about working with financial advisors. So the key phrase that we're trying to get people to understand is what we call wealth reception, and welcome to the era of wealth reception. There's 3 different eras. There's the wealth creation era, wealth transfer era, and then now it's the wealth reception era. So, wealth reception means keeping in mind what is the experience of the receivers of the wealth, and are they prepared to do that? How are they prepared for receiving the wealth? And what are their expectations? What should they expect? Do they know what their role is if they're a beneficiary, and what their rights and responsibilities are as trustees and beneficiaries? So, we'll often ask clients at this point, as part of our presentation, particularly in the second part, when is it okay for the ex-spouse of a beneficiary to get the inheritance you leave in a divorce proceeding? That's what can happen if it actually belongs to them. Well, when is it okay for Medicaid to require that all those assets be spent down, all those assets that you left in their inheritance? Or when is it okay for a catastrophic creditor, like a school bus creditor, to get the inheritance that you leave to them? And typically, people will say never. And so what they want to do is they want to think about what the experience of the beneficiaries are going to do. And this is the trust protections mindset. What is it that we're trying to do? And this is why a lot of people will decide that they want to have trust protections built into their planning. And when beneficiaries learn about what the trust protections are, we often have them asking us to do this kind of planning for their parents so that their property is protected. So it's not just tax planning. Clients want to leave their assets in lifetime trusts, and that's estates of all sizes. It doesn't mean that they have to have multi-millions. It can be, we have people who have less than $1 million and they still want their beneficiaries to get it. And their clients want divorce, creditor, and illness protection, and the ability to leave instructions. And that's really what a lot of the planning is about, not just the taxes. So here's the definition of wealth reception planning. It's a formal process designed to assure you and your loved ones that your true wealth, both financial and non-financial, is fully realized, efficiently transferred, and effectively received. So what we talk a lot about in the second part, that's designing a plan that works, that's the part that's online, is all about the experience of the beneficiaries and how we help them, or how we help people plan with the beneficiaries in mind. So where's the opportunity? Well, there's really several different areas where we think there's opportunities where we should be working with our planning partners. So, there's the process orientation, and we either have or will talk to you about the great relationship divide and how that works. There's the three-step strategy. There's intentional third-party credibility, and we try to give third-party credibility to the people that we're working with. And then there's the fresh overarching message, which is the wealth reception planning idea. So, here's everybody's typical understanding of what a lawyer is, and this is the stereotype that I'm sure you're trying to avoid. And of course, we have our own stereotypes, and these are the stereotypes of advisors that we're trying to avoid. And, you probably wouldn't be on this call if you were in any of those stereotypes, so I don't really have to talk about this. So, as wealth reception focused attorneys, here's essentially some of our principles. It's important for us to share with each other. As a matter of fact, we have part of our agreement with the client that we're going to share with the collaborating advisors. We have a practical orientation, which means, education, planning, and management. We try to have a practical orientation to what's going to happen and how people are going to behave and what people are going to do. We try to use plain English using stories. We want to use the team approach, and the team approach is really a pretty much overused term right now. That's why that question exclamation point marks are there. We have a kind of a different idea of what the team approach means. We want to work a lot closer with the financial advisors and work in an interdisciplinary way on a collaborative basis. So, and that's some of the things that we talk to all of the advisors that we work with about. So what does that mean, interdisciplinary or collaborative? All right, we have, you either have seen or you will see something called the Expectations Communicator, and that's I used to teach a class on the principles of collaboration to advisors, and then I found that the network actually had a document that communicated all those things, so we don't have to teach that class anymore. We just go through it. It's like 3 or 4 pages and talks about all the various different aspects of what it means to collaborate together and the principles behind it. There's another thing that we can do for advisors. That's called the estate plan review letter. Sometimes you'll have a client that has a plan. You'd like to know whether the plan works or what it looks like, or is there anything left out. You can redact their documents if you want to, or give us the documents. We're happy to go through those and give you a report as to what we think is the pluses and minuses of the plan. And if we think they have a good set of documents, we'll tell you. But it's a regular report that we can generate when we analyze what the documents look like. And then, of course, there are the partnering opportunities of various different types. So partnering opportunities are designed to reinforce the relationship with your current clientele. And, of course, that can mean new business, too. But that's what third-party credibility is really about. It's making sure that the relationships you have with your clients are reinforced, because, the most important conversation that happens about you is the one that happens when you're not there. And we recognize that's true about us as well as everybody else. Also, we like to work with advisors about generating new business, with workshop marketing if applicable. There's various different things we can do. And also there are things that we can do together which fall under the category of shared client control. So, what is that? What does that mean? Let's talk about intentional third-party credibility. When we're part of our process, and let me just sort of switch over to the process diagram if I can. Yeah, here it is. When we start off the program, we typically show the clients this is what our process is, and where they are at the beginning of it is right up here in part 1. But that there's a process that they're going to go through, and it's the process that will help them do their planning. But part of the process is this prep meeting right here. All right, so it's quite possible for advisors to actually do the prep meeting, and we actually did a presentation to our Heritage Partners last fall about how the prep meeting is actually supposed to go and why we do things the way we do them and how we gather the information. There are specific forms, et cetera, that we use. And we encourage the advisors to actually do the preparatory meeting with their clients on our behalf. And then because they typically know the clients better or can get to know the clients better than we do and can often ask a lot more questions than we do. And it's easier oftentimes for the financial advisor to gather their information together. So, and it can be a major convenience for the clients. Of course, we're happy to do the preparatory meetings. There are some things that we need to make sure that are done for our own professional obligation. But now that's one of the things that we want to do. One of the other places in our process is called the financial strategies meeting, and that really is where we are actually. I got to get back to that. Here we go. That's the one down here, financial strategy session. That one is specifically designed to talk about funding and how we're going to title assets, but it's also designed to talk about financial strategies. And oftentimes the client will invite the financial advisor to come because it's important to be on the same page in terms of the funding, but also at that point there may be financial issues that we've talked about during the counseling, and now it's time to start talking about those kinds of things and funding those. So we've actually had advisors come and actually sign them up for an account at the financial strategies meeting. And sometimes what we'll do is we'll start talking about advanced planning strategies as a way of trying on some new shoes. Of course, that's not part of the base planning process, but we fully disclose what the fees might be and how things might work for them. One of the other things is called the trusteeship customizer. Let me just go to that. Oh, this is the financial strategy synchronizer. This is something that we want to make sure that clients understand. If you talk about the counseling and design, the maintenance and education, and the estate settlement, when people are alive and well, there are a lot of different financial products and services that they need. When they become disabled, there are financial products and services that they need, and we all know that. But also, when somebody dies, when we have a marital trust for the surviving spouse, we have a lot of financial products and services that may be important for them to be involved with, so that means we need the financial advisors along. And if there's a family trust, of course, the people who are the beneficiaries may need financial services as well and financial advice. Remember that the empty chair is there, and so they need someone to fill it. And then when the second spouse dies, typically what happens is we'll create a common trust for minor children, and or if there are no minor children, sub-trusts for the beneficiaries. And of course, the beneficiaries at that point also need professional help, financial planning, investment advice, etc. So that's important for people to know that at every stage of a person's plan, financial advisors are really required. And so that's one of the reasons why we want to make sure that the client's team is stable and that there's a good relationship between the team members, the professional team members, and the people who are the helpers and family members involved. One of the keys to all of this, of course, is the learning solution, and that's typically starts with the nuts and bolts. It's an education program. We try to get all of the clients and their helpers to participate, and this is where we teach them how to do things and what they're supposed to do. Now, so we have a number of different classes. There are really only two that as Heritage Design, as three-step strategists we're required to do. One's about disability, one's about estate settlement. This year we decided to go into an online education program, which our advisory board, our client advisory board, asked us to do, because one of their major problems is getting their helpers and family members to attend these classes so they can learn what to do. So if we go online and we record them, they can come in if they're from their own desk, if they're in Arizona, California, depending on the time, or they can watch the recording later. And what we're planning to do is to have them answer a few questions about various different classes so that we know they're participating, and then they get the benefit of the program too, because they can call us anytime they want to with any questions. So, what we're trying to do is make sure that they're educated. And in that process this year we have actually 8 different classes that we're giving, some for advanced, that we have a new set of advanced members talking about insurance trusts and insurance, and also about some financial, some advanced planning issues. And so as part of our education program for a Step 2 program for the clients that are in the program, we do need some financial advisors to serve as instructors. You know, basics of insurance and investment, long-term care, and this is some of the stuff that we're talking to our Heritage partners about. Then there's the trusteeship customizer. And what that really talks about is divided trusteeship drafting. All right, this is when the clients leave the assets in a lifetime trust because the clients want that divorce, creditor, and illness protection. So, you know, what we do, this is actually presented in the Designing a Plan That Works, but it's important for people to understand that these beneficiaries have day jobs, they're not fully trained, and some have more talents than others in the kinds of things that are necessary for trust administration. So in this case, for example, Lexi, who's the middle child, is really financially oriented, so she could be a trustee and she could deal with distribution decisions, administrative decisions, as well as investment decisions and participate in those. Whereas Mike is really not somebody who's going to be involved in investments, but he'd like to be involved in distribution and administration of the trust because that's his orientation. And then, of course, there's Matt, who is the youngest child of the family, the artist. He might want to be involved in making some distribution decisions, but administration and investing is probably not his thing. So we can divide up the trusteeship and customize the trusteeship for each of these because we can actually now divide up the various different functions of the trustees and delegate among them so that people can actually have a trust that functions well for them as beneficiaries. So then, of course, there's what we're trying to do is dealing with the relationship that the clients have with their advisors and make sure that that gets transferred along to the helpers because that makes for plan stability, particularly in estate settlement and subsequent to estate settlement when we're talking about the long-term trusts. So oftentimes it's possible for clients to actually request that their trustees use the specific advisors that they have during their lifetime. And when they're doing that, we often ask them something called the Trusted Advisor Test, and here it is. And that is your relationship with this advisor is so strong that you consider his or her advice or relationship an asset that you'd like to pass along as part of your wisdom and your wealth. And if that's true, then it's really important for them to make sure that you're involved in the planning after they're gone or even while they're disabled. So that's the Trusted Advisor Test. So I'm not going to ask you to complete or turn in an evaluation, of course, but the next step for the advisors who've seen this is for us to explore the individual planning possibilities, the kinds of things that we can do together, either for marketing or as part of the process or whatever. And of course, we're asking people to register their clients for the Truth About Estate Planning Orientation Program, which again is given on the second Tuesday of every month, beginning at 6:30. We have one coming up on February 11th. We have, I believe, 6 or 7 clients coming in to it, so we're taking it outside of the office. We're going to have it at the Walker Center. You know, we can always use more people who might want to just find out about what those questions are that they might want to ask. So I just want to thank you all for listening, and let's see, where are we on time? Oh, we're getting close to the end here, I guess. I wonder if there are any questions that anybody'd like to ask.
Frank, I had a question on maintenance. How difficult is it to get them tied into a maintenance program?
Well, usually people people who are working with us, when they've learned about what maintenance means and all of that, they're starting to work with us because they want to do that. And so our big task is to make sure that the maintenance program, because it is voluntary, they sign up every year for it. They don't have to be in it. They don't even have to hire us for estate settlement. You know, it's just we're offering it to them at a particular price based on particular circumstances. But you know, our biggest test every year is our renewal rate, and typically it's been, you know, how many people actually renew every year. Now, sometimes people will move out of state, sometimes people die, and typically our renewal rate is somewhere around 95%. And so that's the other rate that's important for us to understand is what's the rate of people who actually work with us when the time comes for estate settlement. Is everybody there? Hello?
Yeah, I'm here.
Yeah,
okay.
yeah, I'm here.
Right.
How many families actually work with us in terms of estate settlement? And so far, our record is 100%. So, we have about a 95% re-up rate. Just about mainly people who are working with us work with us because we have the maintenance program. And so we don't really have much trouble getting people to sign up or renew. The fundamental difficulty that most of our clients have is getting their helpers to be involved, and that's the thing we've been working on, one of the reasons why we're having an education program online now. So did I answer your question?
Yes, Frank.
Okay. Any other
Frank,
questions?
Oops, sorry.
Go ahead.
At what point are clients deciding to engage with you and essentially hiring you to move forward? I know you kind of talked about the process, and at what point do they kind of commit and say, yes, I'd like to move forward?
All right. That is explained in the Plan Development Organizer, which is this.
Okay, right there. Yep.
All right. So they go to Truth About Estate Planning. We ask them to take a look at Part 2, which is designing a plan that works. They should see that and understand it before they actually do counseling down here.
Mm-hmm.
But the point where they actually sign up with us is at the commitment conversation.
Gotcha.
And that's when we're going over what the commitments are with us and what our process is. We go through a complete disclosure of all the fees, including all the maintenance fees and the different types there are, because we've now added a maintenance program for the long-term trustees, because we realized that there was kind of a gap there. And we've added an advanced program for people who have particular issues and needs. But all those commitments are what we go over with the people at the commitment conversation, and that's when they sign the agreement with us. We actually go through a complete calculation of what all their investment's going to be over time. Great. So that's why the prep meeting is really to prepare them for that meeting and to prepare them for beginning the process. That's where prep meetings where we go through all the financial information, what do they have, and get the specifics of where the accounts are and what property they own and what mortgages do they have, what insurance do they have, because all of that is part of funding. That's really where the funding process starts. But that starts even before we even have an agreement with them. And I'll say the commitment conversation isn't really 2 hours. It can be, it's usually about an hour to an hour and a half.
Great, thanks.
So is that, okay. Any other questions?
Frank, I'd just like to mention to everyone, if you're interested in receiving CE credit for the session today, the second part is February 14th from noon to 2, and I can process 3 credits for you if you complete that, and that would include today's session. So I'll send an invitation out, but you're welcome to come to that. Potential clients may also participate in that webinar because it's the second half of the client orientation meeting where Frank's showing there the Part 2, but a lot of times they end up going to, they'll listen to that recorded session online. But we do the live session because that's the only way to fulfill the CE requirement. So, if you want to let me know, or I can just send out invitations, and you're welcome to come to that.
What are the CE credits? What organizations?
So we can do insurance agent credit through Prometric, the CFP credit through the CFP board, the national one, and we also can do CPA credits.
Can you do SEMA?
I don't believe so. That's an organization that you work with?
It's IMCA is the organization, Investment Management Counselors Association, and SEMA is the designation, Certified Investment Manager Analyst, and CPWA, which is Certified Private Wealth Advisor.
Okay.
I don't know whether you can check. That would be great.
Yeah, CPWA, and what was the other one?
It's SEMA, Certified Investment Manager Analyst. Those are the two designations, and the organization is IMCA, Investment Management Counselors Association.
Yeah, we can look into that.
Right.
Thanks.
Thank
And
you.
if we can't get the credits for you for this one, then we're doing it every month, so you can use this one and take it the next month.
Yeah, I can always use it for insurance credits anyway, but
Yeah,
I'd like to
yeah.
do it for my primary one because I need a few for that.
Okay.
Plus, I like getting educated by you, Frank.
Well, thanks very much. I hope you stay awake. I try not to drone on too much. Any other questions? Well, okay, if there are no other questions, we're going to terminate the session, but just be sure to know that you can certainly call us with any questions you have at any time. I'm sure you've got our numbers. So we look forward to meeting and talking with you in the future, and thank you very, very much for attending, and we hope to see you soon. Thanks a lot.
Thanks for attending, everyone.